This is Dan Dix here reporting for Press for Truth. We're here at the BC courts here in Vancouver today for the case of the father who's potentially facing 30 to 45 days in jail simply for trying to be a parent to his child. And we're joined here with his lawyer, Carey Linde. Now, we just got out of the proceedings, and can you maybe just start us off with just kind of a wrap-up of a nutshell of what today's proceedings were all about?
Well, the provincial crown, the AG, has brought an application, not a charge, not a criminal charge, an application that my client be found in breach of court orders and therefore be subject to the penalties of criminal contempt. And there's a big argument about whether or not this is a criminal trial or a civil trial. I say it's a civil trial. And what we did was that I have asked this judge to recuse himself for perceived bias, and that's been put off to the 30th of November.
And what were the alleged breaches?
The breaches were that he gave an interview in which he permitted his name to be mentioned. That's is a particular breach, and that I believe that he mentioned the name of a doctor who he's not supposed to mention by court order. His defense, if I can put it that way, or his argument is that we're going to make a charter challenge, which means that we say that those orders breach his right to freedom of expression.
Right. So the argument is, as a father, he should have the right to be able to speak about this case, but openly, using his name too, correct?
His name, the names of the doctors, there's agreement, and he certainly agrees that there should be no mention of his child or the child's mother or the child's school. The child does not live with the father. Right. So knowing who the father isn't going to find the child. Yeah.
Is there a possibility for this case to kind of set a precedence for parental rights moving forward here in Canada?
That's a tricky question. I mean, this is not going to be a slam dunk for all that kind of stuff. We are going to, in the course of the argument, point out that he is in a sort of an act of civil disobedience. He's trying to bring to the media's attention the wrongs in the Section 7 of the Infants Act, the problems with the SOGI system, which kept him in the dark about what they were doing with the child, and when I get into the question of the recusal, you'll hear why I think that he's had a bias against him from the minute that the Chief Justice took control of this case way back when it was first filed.
Right. Now, correct me if I'm wrong, but he has no intention of silencing himself about this issue and refusing to speak out about this, right? He will continue to do interviews, but he now can no longer say his name. Is that the new rule?
Well, that was I can't speak for what he's going to do. That's his conscience. Was the existing rule. Yeah. We're going to. If this were a criminal matter, we'd say he's going to plead not guilty. Yeah. But if determined to be guilty, because it's a civil disobedience act, that he thinks they're bringing the attention to rapid onset dysphoria and SOGI and the Infants Act to the attention because the mainstream media is not covering it at all. Right. It's amazing what a big thing this is, and yet nobody talks about it except people like you.
Is this not the first case of its kind where a parent would potentially be facing jail for something like this? Has this ever happened before in Canada?
Well, I have suggested, and I just put it to Crown Counsel, that I am unaware of any family case within which there's been an application for criminal contempt. That doesn't mean it hasn't happened. I just can't find it. And I've sort of put it on the Crown to prove me wrong.
Right. Okay, so what's next? What is the preliminary the date that they've currently set?
On November 30th, there's going to be a day set aside for me to argue, and I'll have to present my application to opposing counsel, that this particular judge, that my client has a reasonable belief that this judge could be biased. You cannot prove actual bias, but there are laws and cases which establish that all you have to do is, would a reasonable man understanding the circumstances feel that there's a reasonable chance this judge will not give a fair hearing.
Right. Well, it seems all along this trial, as I've been following it ever since the beginning, there's been LGBTQ lawyers and activist judges involved in this thing. So it's a real battle you guys are facing moving forward, right?
Yeah, there's a book in there somewhere.
Yeah. No doubt.
I'm not going to write it, but.
All right. Well, the next chapter is going to start in November, and we're going to continue to follow this one and document it. Any just final thoughts for the audience about this case? Because I mean, as you said, a lot of parents don't even have a clue that this stuff is happening.
Well, there's more. A year and a half ago, when this first came up, there was very little in any of the media on this whole issue. It has ballooned beyond belief, and what's happened is that there is tons of scientific evidence to support my client's positions. There never was any science on the other side. It was all subjective. I feel like I'm the wrong gender in my sex body, and so you got to believe me. And the people have to know that they should not be cowed by the trans activists.
Yes, we cannot continue to kowtow to the mob and the pressure of these activists, and we have to stand up for the rights of parents.
Let me say this, and I hope you put this out there because I don't want to be misperceived. My client and I have no problem with adults doing whatever they want. Sure. It's their choice. He's always said to his child, when you turn 18 or 19, you can do what you want. In the meantime, no, you can social transition. But don't make an irrevocable. I mean, the idea that a 13-year-old girl can tell a doctor who tells her, you know, you may not have a child, I don't care. Yeah. I mean, how can that be a mature person? I asked my granddaughters who were in their very early teens, will you ever have a boyfriend? Yeah, never. Right. You know?
Yeah. That's just it, guys. That's the issue. We're talking about a child here who's making life-altering unchangeable decisions moving forward. So again, this is one of the most important cases I've been following over the years, and we're going to continue to track it. So be sure to subscribe if you haven't already. Sir, thanks so much for doing the work to represent this man, which is absolutely important, and we wish you guys the best of luck moving forward.
Thank you.
We're here at the BC Supreme Court with the man who shall not be named, the man in question right now, who is facing criminal contempt charges simply for speaking out about having the right to be a parent to his child. So can you maybe just start us off with how the proceedings started off today? As I understand it, they initially put you in the prisoner box. What's that all about?
Yeah, this is a criminal trial supposedly, and as a result, I have a special place, a special seat that's all my own in what they call the criminal docket, or the prisoner's docket. Carey Linde happened to be a few minutes late, and when he came in and saw me sitting in there,
Your lawyer.
which is my lawyer, Carey Linde, he right away turned to the judge and said, "What is my client doing sitting in the prisoner's docket?" And as it turns out, it was actually the lawyer for the government that had said I need to be sitting in there. And after some commotion, they actually took another chair and put it beside the prisoner's docket, so I was still sitting up front, but out of the prisoner's docket. And that was kind of how things kicked off a little bit this morning, so with a little bit of drama.
Now, the whole reason why you're here in the first place is for an alleged breach of their order. What were these alleged breaches?
You know, that it didn't really come out today in terms of what they were specifically, but I mean, my understanding is that it's for doing interviews, showing, you know, using my name, and of course everything's under right now, you know, a publication ban, but at the time conduct orders I was under as well. And so that's what they're alleging, is that, you know, I ignored all this and just to get the story out. And of course, my feeling is that the story needs to get out to the Canadian public. This is super important. It's of national, if not international, importance, is my feeling. And so we're going to be running a defense of civil disobedience. And we're just going to simply come out and say that this is so important that, you know, the government shouldn't be shutting a story down. They don't have the right to take away my freedom of speech in this. They're violating my rights, and we're going to go at it from that.
This is an absolutely beautiful display of civil disobedience. Now, if they do decide that you are in further breaches of this publication ban moving forward, what are you potentially facing here?
Well, definitely incarceration. That's without a question. And my understanding is 45 days of incarceration. In fact, near the end of today's hearing, my lawyer, Carey Linde, wanted to sort of have the judge clarify again what this publication ban is. And then the judge kind of pointed to me and said, for all of you out there, if you think you can get away with naming doctors or whatever else it is, you're going to be like this man, and I can't, he said my name, but I won't, this man, Mr. CD, and facing incarceration yourself. So he tried to kind of threaten the entire gallery by saying this is consequences for speaking. I mean, because these are sealed files. And again, at the very beginning of the hearing today, the judge again even said that he doesn't even have access to these sealed files. He again made that clear at the start of the hearing. So
now, from what I can tell, there's been a lot of LGBTQ lawyers, a lot of literally activist judges. So I think you're at a pretty big uphill battle moving forward here. But is there any possibility for them to be able to assemble a super powerful team to be able to make sure that your case doesn't make it to all the way to the top?
Well, this is a pretty new development, and I've spoken to it a couple of times now, is that this case should have been done with at the time of when Bowden made his ruling. They didn't expect this to go further. I spoke with the Federalist. That got Mazzari, another justice, involved. And then moving forward now, notwithstanding the Court of Appeal and a bunch of other stuff, and I did have Chief Justice Hingston sit on ahead of the Court of Appeal for a stay application for cross-sex hormones. And now, of course, we have Justice Tammen. But because this thing keeps going on, these secret sealed files somehow mysteriously seem to be getting leaked at times. And so another interesting one came up, and that is that the Chief Justice Hingston had seized himself to this case even ahead of me being in front of Justice Bowden. Now, the way a case is supposed to operate is that the judge doesn't know the case. He gets a file put in front of him. Myself as a client and my lawyers don't know who that judge is going to be, or lawyers for the other side. And that's supposed to paint this picture that this is going to be a fair trial, right? We're both coming into it without any knowledge of each other or the judge of the case. Now, what happened is that is not at all what happened here. Chief Justice Hingston seized himself to the case, appointed judges the whole way through, including himself. And so I would say this thing has been rigged from the beginning against me. And it's just because of the fact that, just keep pushing in this case. I mean, more and more stuff is coming out. Like, we're seeing things going on here that should concern every Canadian. I mean, freedom of speech, parental rights, allowing minors to consent to crazy things that are irreversible, like cross-sex hormones and sterilization, and then a whole agenda with a government and a court system that, I mean, this whole thing is so political right now that there's no other way to put it. This is just, I mean, this is stuff that shouldn't be happening in a democracy.
Absolutely. I mean, let's face it. What we're talking about here is a child being influenced by the schools, the SOGI 123 program, and by these counselors being recommended to doctors who then pushed the idea of transitioning on this young girl. And the father is saying, well, hey, if you want to do that, that's fine when you're 18, but you're a little young for that now. And you are now the one facing 45 days in jail simply for literally just trying to be a parent to your child. That's what it's come down to.
That's what it's come down to, yes. And another notable point is that, this was it was both a family suit and it was a civil suit or a civil case. And they have turned this into a criminal case.
Yeah. And your daughter, as I understand it, has no intention or will of you going to prison, right? This isn't her pushing this on you.
No, my daughter's instructed her lawyers, Finley and Friends, but she did not want to push any kinds of civil contempt charges against me. And yet counsel for AB went ahead and implored the judge to do it anyways. And he responded by doing exactly that and inviting in the government of British Columbia to go after me with charges. Yeah. And, and again, even today in the hearing, there's so much confusion because even the judge is saying this is such a unique case. He goes, it is a family case because we're going under the AB versus CDEF one, which was the family one. The civil one was mine, which was CD versus everybody, government, schools, counselors. But this right now is based under the family file, and even he doesn't know. He goes, "This is a quasi criminal case," and I don't think they have an idea how to proceed with this. I mean, that was a bunch of what we dealt with. Like, what is this case? What kind of file is this? And again, it shows you that this is all stuff that's never been done. And why is it getting done? Well, it's political. They're trying to figure out whatever way they can to squash this. And I tell you, I don't know that they can.
I hope so, Rob, CD. I hope so, and we're going to do everything that we can to continue to bring this information to the light of Canadians who deserve to hear it. And you know, on the potential bright side, if you do end up facing criminal charges and going to jail, maybe we can make a huge noise about that and essentially martyr you for parental rights moving forward in Canada. So any final thoughts on where this is going and what's the new date now?
Yeah, I was going to say, I appreciate everyone that keeps showing up. And the next date is tentatively set for November 30. And what's happening there is we brought an application, or we'll be bringing an application to have Justice Tamman recuse himself, because we don't think we're going to get a fair trial from Justice Tamman. We think he's biased on this. And so that's the next point of business. And like I said, that'll be, tentatively scheduled for November 30.
All right, well, we are going to continue to follow this one, guys. Be sure to subscribe to the channel if you haven't already. We'll be there in November. So once again, thanks for talking to us, and really keep this up, especially in the face of such evilness and wickedness moving forward. Great work.
Thank you, Dan.
We all want truth. The truth will set you free.